Hey. Guys are late. I am so late. Sorry about that. Sorry. I'm a late bird. Got two people in the chat. Hey, guys. I am late. I will continue the book. Guilt by Accusation by Alan Dershowitz. Got two folks in the chat. I went to get something to eat. That's the reason why I'm late. Hey, Laquita. I'm continuing the book. I went to get something to eat. I was supposed to be back on at 10, but I'm continuing the book because I know a couple of people asked me about continuing the book. And I just had forgotten all about it. Hey, Shannon. Hey, Cha-Cha. So I'm going to continue finish the book. All right. Here I go. I'm going to start it. I'm going to start the book right now. This is Guilt by Accusation with Alan Dershowitz. He was accused of having sex with an underage minor. And he never actually met the girl. I started this a couple of days ago, and I want to go ahead and continue it, finish it off, so you guys can hear the situation, what happened. Okay, I'm going to turn my camera off because I'm chewing. Oh, Cha-Cha, I am so sorry. I owe you a phone call. This is roughly about an hour left of this book. So I'm just gonna play it. And hey, Shannon, did you come for the first part of the book? I think you was here before. So I'm just go ahead and play it. Hey, Princess Diana, you working? You listen? Okay. Did you hear the first part? Who was here for the first part? Because I'm just continuing where I left off. That I was waiting for a couple of other people who's been listening. I was trying to wait till they come in. Just bear with me a minute. I'm going to change my camera here so nobody sees me eating my food. I decided to get a nacho from Taco Bell. They had that big nacho thing, party nacho. You listening? Okay. I've been trying to wait about 8 more minutes to see. I'm going to start exactly at 10:30. See if anybody else. Okay, Laquita. Okay, Laquita's here. You heard some of it? Okay. But he's a person that is coming to this channel as my special guest. I believe he will be very instrumental in what we're doing. He'll help us to understand some things in regard to the law. He is a wonderful person, and you guys should go to his channel and watch it. It's called Dirch, and he breaks down a lot of things with the law. Especially those who are interested in finding out a lot of things about what's going on as far as the law. And he's very candid about his opinion about certain things and what the law has been on their side. As him being a Caucasian male, he sees the injustice that is being done in society and laws in regards to people. There are brown and black, and how people who have economic deficiency has suffer in the sight of law, because it seems like he mentioned, like, when I was talking about the guy who was being executed, Bernard, he was executed, and he was saying how his he didn't have a great legal defense team, and that he was only being executed because he was poverty stricken and he was a young man. So I'm going to play Dershowitz, him being accused of having sex with an underage minor. And this is what his story is of what he went through. And I'm on part 2 of this because a lot of us was here about a week ago listening to this. And I did reach out to him to ask him to come on my channel and be a guest, and he accepted my request. We're just trying to get together, find out what day is best, and he's been working hard because today was part of the electoral vote thing to make a decision of the presidency, and he's been working hard on that. So kudos to Mr. Alan Kurt Dershowitz. He is, I can't wait to have him on our show. So here it is. Without further ado, we have a few minutes left on this recording. Here we go.
Swearing that she had seen me in Epstein's house when she worked for him. She swore she saw me in the presence of young women, although she said she didn't witness any wrongdoing on my part. The problem with her affidavit is that I didn't even meet Epstein until well after she stopped working for him, and was never in his house until months after she stopped coming there. The documented chronology makes it impossible for her to have seen me in his house, yet Boies submitted her perjured affidavit knowing I hadn't even met Epstein and was certainly never in his house until well after she terminated her relationship with him. Thus, the pattern of perjury is clear. 3 women, all represented by the same lawyers, changed their stories in an effort to incriminate me only after meeting these lawyers and apparently being pressured by them. I believe this insidious pattern should be investigated by law enforcement. Subornation of perjury is a serious crime, especially when committed by lawyers. A pattern of subornation is even more serious. If such a pattern in fact occurred with 3 perjuring women, and if that perjury was suborned by lawyers, there should be legal consequences. In any event, none of these 3 women should now be believed, based on the indisputable evidence that they are lying. 3 false witnesses are not better than 1, especially if all 3 are represented and pressured by the same lawyers. Some may say that where there's smoke, there may be fire. But in some cases like this one, the smoke may be a sign of arson, of 3 fires set by the same team of arsonists. Chapter 9, a mystery following Epstein's suicide. Why did David Boies drop the ball against Leslie Wexner? When I was informed that my former client, Jeffrey Epstein, may have tried to kill himself in jail, I was not surprised. Based on the evidence in the case, it seemed apparent that Epstein was a hedonist who cared about his body, his comforts, his pleasures, and his well-being. I never saw him drink or use drugs. He ate very little. He worked out. His pleasures obviously focused on sex. I was surprised that Epstein flew into the Teterboro airport while an investigation on him was ongoing. He could easily have remained in Paris, where he owned an apartment. I had never seen his Paris condo, but I'm told it was quite beautiful. Had he stayed in France, the U.S. would have sought to extradite him, but it's uncertain whether they would have succeeded. Recall that Roman Polanski, whom I had briefly represented, lived openly in France despite American efforts to extradite him when he fled California, following his guilty plea for having sex with an underage girl. Epstein was probably unaware of the investigation and indictment by the U.S. Attorney's Office in Manhattan. He must have been shocked to be arrested. He must have been even more shocked to see the inside of a federal detention center that would be his new home. I have been in that facility to visit clients, and it is hell on earth, even for inmates who are not used to living in the palatial homes that Epstein owned. When the government opposed his pretrial release, Epstein probably realized that he might never again experience freedom. Prosecutors win the vast majority of their cases and motions, and if convicted, he was facing a sentence that would likely keep him in prison for the rest of his life. I suspect that he did not see any light at the end of the tunnel and did not want to spend the next several decades as a federal prisoner. So suicide was an obvious option. Though I was not surprised when Epstein attempted suicide, I was shocked when a few weeks later he succeeded. It is nearly impossible for a prisoner on suicide watch to kill himself. Such prisoners are denied access to the material they would need to hang themselves: belts, shoelaces, sheets. They are continuously monitored by guards and video cameras. But Epstein was not only taken off suicide watch, his cellmate was moved and he was left alone and unmonitored with his bed sheets. It is almost as if they were inviting him to hang himself, which he did. The autopsy confirmed suicide, but there are skeptics, including some of his current lawyers, who are prepared to appeal the denial of bail and to defend him vigorously at trial. There will be an investigation, but I doubt there will be hard evidence that he may have been killed by others. Epstein's death caused understandable anger among his victims and alleged victims. The judge who was supposed to preside over the criminal trial invited his alleged victims, including my false accusers Gouffre and Ransom, to speak in court. Neither mentioned me. On the courthouse steps, Gouffre demanded that Prince Andrew come clean, but she didn't dare accuse me because she knew that I would sue her if she repeated out of court her perjurious lies that she had told in court papers. Epstein's death left many unresolved mysteries which should be investigated. At the center of these mysteries is Leslie Wexner. Wexner's business relationship with Epstein have received considerable attention, but there has been little coverage of the long-term personal relationship and the accusations made by Gouffre that Wexner had sex with her and perhaps other young women. A deep mystery surrounds the decision by attorney David Boies not to pursue Wexner, to whom, according to Gouffre, she was sexually trafficked by Jeffrey Epstein on multiple occasions while she was underage. Readers may be unaware of these allegations because Boies deep-sixed them after meeting with Wexner's lawyers. The question is why? Did Boies not believe his client's accusations against Wexner? If he did believe them, did Wexner pay hush money to keep the accusations from becoming public? The answer may be in the following documented but suppressed story that I have asked prosecutors to investigate. In mid-2014, Gouffre's original lawyer, a former assistant attorney general named Stanley Pottinger, asked Boies to help represent Gouffre. Boies agreed. According to a sworn affidavit filed by Pottinger, quote, "In the fall of 2014, I asked Mr. Boies if the firm represented or if he knew Mr. Leslie Wexner. I told him that in the course of investigating facts relating to Mr. Epstein's sex trafficking, Mr. Wexner had been identified as a close business associate and personal friend of Mr. Epstein. I told Mr. Boies that there were assertions that Mr. Wexner had permitted Mr. Epstein to use and entertain on Mr. Wexner's yacht, and that Mr. Wexner was alleged to have had sex with one or more of Epstein's girls, including Miss Gouffre." End of quote. The Pottinger affidavit disclosed that in December of 2014, precisely the same time I was being publicly accused in court papers by Gouffre of having sex with her, Boies' firm asked to meet with Wexner privately. Boies and his partner then met with Wexner's lawyer and told him, according to the lawyer, that Gouffre was accusing him of sexual misconduct similar to that of which she was falsely accusing me. As I've said, both Wexner's wife and his lawyer used the word shakedown when telling me about Boies' approach to Wexner. They also said the accusations were untrue. We don't know precisely what transpired at the secret meeting, but we do know from records of the case that following the meeting, Wexner's name disappeared from court filings and no public accusation of the kind made against me was ever leveled against Wexner by Boies and his client. In the recently unsealed depositions of Gouffre taken in 2016, she accuses many prominent people of having sex with her, but not Wexner, though she had earlier accused him in secret. Wexner's disappearance from the Epstein case is surprising, indeed shocking, in light of Wexner's wealth and long-term personal and business associations with Epstein. Maria Farmer, whose credibility is questionable, has sworn that she was assaulted by Epstein on Wexner's property after Wexner hired her to work with him, and that Wexner's security staff, quote, refused to let her leave the property where she was being held against her will for 12 hours. As I have repeatedly said, accusations against me, which were deliberately made public, are refuted by the evidence. Yet they were deliberately made in publicly filed court documents and then leaked to the press in order to gain maximum publicity. Just as these accusations became headline news, Wexner was approached privately with similar accusations. The timing does not appear to be coincidental. It would be commendable if Boies indeed had met with Wexner's lawyer in order to thoroughly investigate the accusations, as the Pottinger affidavit claims. If Wexner's lawyers persuaded Boies that his client was lying about having sex with Wexner, that would be a good explanation for why they would not thereafter have publicly accused Wexner. But it doesn't explain why they continued to publicly accuse me after concluding that the very woman who accused me, the same one who accused Wexner, was a liar who made up similar false stories about another prominent man. If, on the other hand, Boies believed that Gouffre was telling the truth about Wexner, why would he have possibly allowed this prominent multi-billionaire to get away with having repeatedly abused his underage client. Boies sued Ghislaine Maxwell and Epstein on behalf of his clients and received generous settlements from which he received contingency fees. Now Giuffre is suing me, as I will describe in chapter 12. Why did he let this mega wealthiest person, most closely connected to Epstein, off the hook? Did money change hands? There is no third possibility. Either Boies concluded that Giuffre was lying about Wexner, in which case she should not be believed about me, or he concluded that she was telling the truth about Wexner, in which case Boies has to explain why he covered up this billionaire's serious crimes against his client. It's, of course, logically possible that Giuffre was lying about Wexner, as well as the Gores, Clinton, her age, and other issues, but telling the truth about me. But as Oliver Wendell Holmes once wisely observed, the life of the law has not been logic, it has been experience. And experience teaches us that a witness who has falsely accused others and lied about relevant matters should not be believed. Giuffre's own lawyer, David Boies, acknowledged this when he told me that she was wrong about meeting me on the island, ranch, and other locations, so she should not be believed about meeting me in New York. Not only did Leslie Wexner's name completely disappear from the case after his lawyer met with Boies and Macaulay, but Giuffre's lawyers went out of their way to pronounce him innocent of any wrongdoing. Here's how Bradley Edwards, Giuffre's Florida lawyer, put it when asked on July 16, 2019, whether Wexner was involved with any of Jeffrey's sexual misconduct. Quote, I believe, based on the information that we have accumulated over 11 years, that the statements that he gave yesterday in the press, that he did not know about the sexual proclivities of Mr. Epstein, are very likely to be true. We have not seen where he is in the company of Jeffrey Epstein at the time when he was engaging in these things. In fact, it is very seldom that any of the victims ever met him or saw him. I know there are lots of business ties to him, but other than receiving any information about the business connection, I don't have any information to believe otherwise. That's the end of the quote. This interview was highly significant because Edwards was speaking as Giuffre's lawyer and agent. In doing so, he was admitting, much like Boies had previously admitted, that his own client was a liar and a perjurer. Recall that Giuffre testified under oath that she had sex with Wexner on numerous occasions under circumstances nearly identical to the false claims she made about having sex with me. She has also accused Wexner of making her wear Victoria's Secret type lingerie while he had sex with her. Giuffre also told another of her lawyers, Pottinger, that Wexner had sex with her and may have had sex with other women associated with Epstein. But that was all before Boies and Macaulay met with Wexner's lawyers. If in fact Wexner paid hush money to buy Giuffre's silence, then it would be understandable why Edwards was prepared to deny that she had sex with Wexner. But this has the effect of throwing his client under the bus by in effect calling her a perjurer for swearing that she did have sex with Wexner. If Edwards made this dramatic and damning admission because he knows Giuffre lied about Wexner, then he surely should not have believed her nearly identical false claims about me. This is a deep conundrum for the Giuffre team, and one that may well suggest serious criminal conduct. And there is more. In a previous interview, Edwards said that based on his own 11 years of investigating Epstein-related charges, he, quote, doesn't know of any high-profile people who would be implicated in sexual misconduct. So again, he is calling his client a perjurer because she testified that among the people she was forced by Epstein to have sex with were many extremely high-profile people, such as George Mitchell, Bill Richardson, Ehud Barak, and others. It is, of course, possible that Giuffre's lawyers are seeking hush money from these and other prominent people who have been accused by Giuffre, whether falsely or truthfully. Anyone who doubts that Boies and his firm are capable of such tactics need only look at the case of Emma Klein, a young novelist who received the Boies treatment. Boies and his firm represented the ex-boyfriend of writer Emma Klein, who wrote the acclaimed novel Girls, a fictional account of a woman's relationship with Charles Manson. The ex-boyfriend, Chaz Reitz Lialo, alleged that she stole his writing for her book, and invaded his privacy via a spyware program installed on her laptop. The boyfriend had used her computer during their relationship and later bought it from Klein after their romance ended. In an effort to settle the case, Boies and his team sent Klein and her lawyers a draft complaint with Boies' name that sought to stop the sale of Girls and the movie deal based on the book. The draft complaint came with a not-so-veiled threat of what would happen if no settlement was reached. As the New Yorker reported, and I quote, Boies Schiller responded by sending a 110-page draft of a complaint that it said was prepared to file in court if the two sides did not reach a settlement. David Boies' name appeared at the top of it. Reading through the allegations, Klein was stunned to find a section entitled Klein's History of Manipulating Older Men, which purported to illustrate how Boies Schiller would easily discredit her arguments about her former boyfriend's treatment of her before the jury. Evidence shows that Klein was not the innocent and inexperienced, naive she portrayed herself to be, but had instead for many years maintained numerous relations with older men and others from whom she extracted gifts and money, the section began. What followed were 13 pages containing screenshots of explicit chat conversations with lovers, including one in which Klein had sent a naked photo of herself. The photo was blocked out in the letter to her boyfriend. Explicit banter with people she'd met online and snippets of her most intimate diary entries. All of this material had been recorded by the spyware and remained on Klein's old laptop, which her boyfriend now had in his possession. That's the end of the quote. Klein's lawyers disclosed the draft complaint with those salacious details. In their counter-complaint, Klein's lawyers minced no words in describing Boies Schiller's tactics. Quote, the boyfriend's allegations follow a pattern that started during their relationship and apparently fits with the playbook of his counsel, of prying into and exploiting Klein's sexual history to threaten her, even going so far as to make the false and absurd claim that she was an escort. The boyfriend and his counsel's extreme and aggressive campaign against Miss Klein moved into farce when they implied that the boyfriend's damages from his injuries could approach billions of dollars, end quote. As with Giuffre, it was only after the boyfriend met lawyers from Boies Schiller firm that he apparently hatched a plan to turn a frivolous and time-barred legal claim into a big day payout. I quote again from the New Yorker. Because of the spyware program, which had captured and stored records of Klein's computer activity while she owned the computer, the boyfriend has been in possession of a trove of personal information about Klein since he purchased her computer in 2013, including her private correspondence, journal entries, intimate browsing history, and photographs. However, even after he discovered the program, the boyfriend did not immediately understand the extent of what he had in his possession. It was only in 2016, after he began to realize the weakness of his copyright claims against Klein, that the boyfriend realized he could exploit the trove of Klein's most personal information. Thereafter, in keeping with his long history of using extortionate threats to control Klein, the boyfriend hatched a plan to exploit this information to shore up his wilting copyright claim and extract the financial windfall from Klein and Random House through alternative means. He threatened to reveal her past and her use of the spyware software, not because he believed he had a credible claim, but in order to extort the maximum financial settlement from Klein. That's the end of the quote. Although the Boies Schiller law firm knew or should have known that the boyfriend had no credible legal claim, they went ahead with the lawsuit, as Klein's lawyer recounted. Quote, on March 30th, 2017, the boyfriend's counsel followed up with their February 2017 letter with a draft complaint setting out their supposed claims. In the first draft complaint, the boyfriend and his counsel were far beyond what would be necessary to set out the claims based on Klein's use of the software for copyright infringement. The first draft complaint made aggressive, transparently threatening use of personal information the boyfriend had found on the cache of the spyware that he considered most likely to humiliate Klein. Emboldened by a perceived legitimate legal hook He and his counsel included in the first draft complaint screenshots of Klein highlighting and copying erotic literature from the internet into a document, alleging that these were a further example of Klein's plagiarism. However, the first draft complaint identified no corresponding instances of any language from the cited erotica appearing in any of Klein's work. These allegations were included in the first draft complaint purely to humiliate Klein, to bully her into settling for an unreasonable sum rather than have this extraordinarily personal information aired in open court. End of quote. If that was not bad enough, the Boies-Schiller firm doubled down in their revised draft complaint. And I quote, "A revised draft complaint falsely accused Klein of being an escort and attempted to sexualize and smear her platonic relationship with a benefactor, who it also named. In short, the second draft complaint, with the input of the Boies-Schiller firm, followed an age-old playbook. It invoked the specter of a sexual shame to threaten a woman into silence and acquiescence." End of quote. This episode was reported in the New Yorker and the New York Times, and Boies-Schiller was criticized for its behavior. David Boies has been criticized for his role in the Weinstein case as well. Legal ethics scholar Professor Stephen Gillers told the New Yorker, quote, "Lawyers can refuse to engage in tactics they find morally repulsive. This is especially true here because the screenshots, even if not entirely extraneous to the dispute, are of barely marginal relevance," end quote. Boies-Schiller's general counsel stated that David Boies had no involvement in the matter. Quote, "Boies had nothing to do with the draft or filed complaint, but he did participate in one settlement decision," end quote. However, while Boies' name was omitted from the complaint that was actually filed, the fact that he used his name in the draft complaint was obviously aimed at intimidating Klein and her lawyers. They refused to settle the case. A California judge ruled in Klein's favor and dismissed the lawsuit. If these tactics sound similar to the ones allegedly used by Boies against Wexner, it is because they derive from the Boies playbook. Epstein's death will not end the investigation. Among the mysteries that should be explored are whether Gouffre committed perjury when she accused Wexner and other prominent men of having sex with her, or whether Boies engaged in a shakedown and or received hush money for Gouffre to cover up Wexner's alleged crimes. Chapter 10, the weaponization of the media to defame and sue. Unsavory lawyers have developed an insidious tactic by which they can falsely accuse innocent people and then sue them for defamation if they deny the false accusations. These lawyers have weaponized the media in aid of this tactic. Some journalists, such as Julie Brown of the Miami Herald and Connie Brooke of the New Yorker, have worked hand in hand with these lawyers to promote their own careers and ideological interests over a commitment to the truth. This is how this dangerous partnership works. The lawyers pressure a client into making a false accusation, but they are careful to make it only in court documents that are protected by the so-called litigation privilege, even if it's irrelevant to the court proceeding, as the judge ruled it was in my case. This privilege protects anything said in a court document or proceeding from a defamation suit. The false accuser or lawyers then leak the judicially protected false accusation to the media, which is also protected against a defamation suit for reporting on what was said in court papers or proceedings. The media then published the false accusation without requiring the false accuser to repeat the accusation to the journalist outside the protection of the privilege. The false accuser and her lawyers can in this way launder the defamatory accusations through the media and achieve the same result they would have achieved had they made the accusation directly to the news media. But, and here is the critical element, without incurring the risk of defamation suit for making a false accusation. Moreover, because the accusation is made in court papers, some readers believe it has the imprimatur of the courts and therefore is more credible than if it had been made directly to the media. The victim of this false accusation then has only three options. The first and most obvious is that he can immediately respond to the media report of the false accusation in the media. But his response may not be protected by the litigation privilege because it is not made in court papers or proceedings. He can therefore be sued for defamation for merely denying the accusation and saying it's a lie. The second option is to respond in court documents or proceedings and thus be protected by the privilege. But filing court papers or appearing in court takes time, and it is imperative to respond to false accusations immediately within the news cycle if the denial is to be reported and credited. A court filing made days or weeks after the initial accusation was reported in the media will either not be reported or if reported will be buried. The third option is to ignore or no comment the accusation and hope it will go away. An entirely innocent, falsely accused victim should not be satisfied with the story going away. He should categorically deny and disprove the false accusation. I chose the first option, immediately responding in the media. I went on television, categorically denied the charges, and accused my false accuser and her lawyers of making up the entire story. I wrote an op-ed for the Wall Street Journal in which I exposed the tactics of the lawyers and warned that what they did to me could be done to other innocent victims unless something is done to end this abusive tactic. Here is some of what I wrote on January 14th, 2015, just 2 weeks after the accusation was made against me. Quote, you challenge the lawyers who filed the court document to repeat the false charges in the media so you can sue them. They remain silent. You challenge the woman, now 31 years old, to bring rape charges against you, and you offer to waive any statute of limitations because the filing of a false rape charge is in itself a serious crime, though it is rarely prosecuted. She doesn't accept your challenge. And then, sure enough, the lawyers who made the false accusation sue you for defaming them, although they claim you can't sue them for falsely accusing you of a crime. Welcome to the Kafkaesque world of American justice. But Kafka was writing fiction when he described the ordeal faced by Joseph K. in his famous novel, The Trial. What I have described is real. It is happening to me right now, and if it can happen to me, it can happen to anyone. I then described how I felt, quote, I may never have the opportunity to prove my innocence or to have my accusers prove the false charges in any court of law, but because I am relatively well known, a double-edged sword in these situations, I can at least fight back in the court of public opinion, though at the very, very, very high cost in legal fees, loss of insurance coverage, and the possibility of large monetary judgments against me. Imagine the same thing happening to a person who did not have the resources to fight back. Finally, I proposed a remedy. The law must be changed to shatter the hall of mirrors I face and others might face. There must be consequences for those who file accusations with no offer to prove them and no legal responsibility if they are categorically and disprovably false, end quote. But the law has not yet been changed, and so the insidious tactic is still being deployed with the assistance of the media. It encourages and incentivizes the leveling of knowingly false accusations in court filings that are then deliberately leaked to the media and published by them without any corroboration or on-the-record confirmation. The United States Court of Appeals for the Second Circuit has, however, recently cautioned the media against allowing itself to be weaponized in aid of this tactic. Here is the note of caution issued by Judge Jose Cabranes, quote, to the public regarding the reliability of court filings. It should be read and acted upon by every media publisher, editor, journalist, and reader. I quote from Judge Cabranes' decision. Materials submitted by parties to a court should be understood for what they are. They do not reflect the court's own findings. Rather, they are prepared by parties seeking to advance their own interests in an adversarial process. Although affidavits and depositions are offered under penalty of perjury, it is in fact exceedingly rare for anyone to be prosecuted for perjury in a civil proceeding. Moreover, he continued, court filings are in some respects particularly susceptible to fraud. For while the threat of defamation actions may deter malicious falsehoods in standard publications, the threat is non-existent with respect to court filings. This is so because under New York law and the law of most other states, absolute immunity from liability for defamation exists for oral or written statements made in connection with a proceeding before a court. Thus, although the act of filing a document with a court might be thought to lend that document additional credibility, in fact, allegations appearing in such documents might be less credible than those published elsewhere. The judge continued, the media does the public a profound disservice when it reports on parties' allegations uncritically. Even ordinarily critical readers may take the reference to court papers as some sort of a marker of reliability. That would be a mistake. We therefore urge the media to exercise restraint in covering potentially defamatory allegations, and we caution the public to read such accounts with discernment. That's the end of the quote. Judge Cabranes' wise caution raises a broader issue of journalistic ethics. Should the media report an accusation by an accuser in court-protected documents when the accuser is not prepared to make that accusation on the record outside the protection of the litigation privilege? The truth or falsity of accusations made in court pleadings cannot generally be tested or challenged in a judicial proceeding. If the accuser is not even willing to make the accusation on the record with the journalist, it seems unfair for that journalist to repeat the accuser's accusations, especially if uncorroborated. Why would a reporter who is interested in the truth not press an accuser to repeat and defend her accusation on the record? If the accuser refuses, the reporter should at the very least report that refusal. As we will see in the pages to come, many journalists do not even do that, especially with Me Too accusations. The issue needs to be debated within the media and by outside experts. By publishing accusations made only within the litigation privilege, without requiring the accuser to go on the record, the media encourages deliberately false accusations made out of extortionate, vengeful, or other improper motives. Because there are no legal consequences for the accuser, even if the accusation is proved false, such accusations will increase, especially in the current Me Too era, when it is politically a sin to disbelieve a woman, even if there is evidence that she is lying. A heavy burden of proof is on the accused to prove his innocence, and even if he satisfies that burden, as I did, there will be those who continue to believe the accuser. The media should require all accusers to repeat accusations they made in court submissions to a journalist on the record before spreading a potentially false accusation around the world, but they generally don't. The worst offender in this regard is Julie Brown of the Miami Herald. Brown calls herself an investigative journalist, but in reality, she is a one-sided polemicist who gets her information not from independent investigations, but rather from adversarial lawyers who are interested in promoting an agenda rather than reporting complex or nuanced truth. Her reporting on the Epstein case was hand-fed to her by Virginia Robert Gouffre's lawyers. They provided her with this one-sided information, apparently in exchange for an understanding that Brown would report only Gouffre's side of the story, which turns out to be highly questionable in general and completely made up with regard to her accusations against me. Brown interviewed Gouffre for a Miami Herald video, but refused to ask her on camera to repeat her accusation against me. She knew that Gouffre would not do it. Instead, Brown allowed her to say she had sex with unnamed politicians, businessmen, and academics. When Gouffre said the word academics without specifying me, Brown flashed my photograph on the video screen. She did not report that Gouffre had refused to go on the record to name me, or that Brown had a deal with Gouffre's lawyers not to ask her specifically to name me. Rarely have I seen more irresponsible and unprofessional journalism. I provided Brown with documented evidence of Gouffre's long history of lying about the Gores, Clinton, her age, and other issues. I also provided her with detailed evidence of Ransom's lies about Hillary Clinton and others. Not only did Brown refuse to include these histories in her reporting, she lied about what I provided her. Here's what she wrote. Quote, Dershowitz has attacked both women's credibility, in particular pointing to falsehoods in some of Ransom's past statements. He says he has proof that both are lying, but he has never presented it publicly. That's her quote. This is categorically false. In an appendix to this book, I provide one of several emails I sent Brown documenting their history of lying, as well as documented facts that she has refused to include in her biased reporting. Among the information I provided her, which she did not publish, was the following, quote, overwhelming evidence of Gouffre's long history of perjury, lying, including false claims of meeting Alan Tipagore and Bill Clinton on Epstein's Island. Her own lawyer's statement that she did not tell the truth about having sex on multiple occasions with Leslie Wexner. Roberts deliberately lied about her age to falsely claim that she was underage. Gouffre's claim to have had sex with George Mitchell, Bill Richardson, Ehud Barak, Rebecca Boylan's statement that Gouffre was pressured into naming me, Boies' admission that Gouffre was simply wrong, and the emails and book manuscript that prove Gouffre had never even met me. When I pressed Brown about these omissions, she responded, "That was not the story." I invited Brown to review my travel records for as long as she wanted. She spent several hours poring over them, and then said she had to leave because her parking meter had run out. I urged her to return to complete her review, but she insisted that she must take my records with her. I believe the only reason she wanted to take the records with her was to give them to Gouffre's lawyers so that they could try to find dates in which we were both in New York. I repeated my offer to review the records for as much time as she needed and to take as many notes as she wanted. She declined my offer and then falsely reported that I refused to allow her to inspect the records. Brown also asked me to break the law. Here is our exchange regarding the sealed emails that Sarah Ransom had sent to the New York Post, claiming she has sex tapes of Hillary Clinton, Donald Trump, Bill Clinton, and Richard Branson. Quoting from my own email, quote, "I am not permitted to send them. I am subject to a sealing order. Ransom is not subject to that order, and she can show them to you. If she refuses, it's because she has something to hide. I would love to send them to you. Ask her and her lawyers whether they consent to have me send them. If they refuse, you should report that." And here's Brown's email. "Alan, you can send them. There are many documents floating around in this case, so I'm sure no one will go after you." End quote. I believe that her reference to many documents floating around is an admission that Gouffre's lawyers had already shared sealed documents with her, as I know they have with other journalists with whom they have collaborated. My lawyers cautioned me that the reason she told me I can send the sealed documents to her was not because she was interested in reporting their content, which would undercut her narrative, but because she wanted to tell Gouffre's lawyers that I had broken the law by sending her sealed material. I did not fall for the ploy. I responded to her request to break the law by emailing, quote, "I will comply with the law, even if you are asking me to break it." Brown's one-sided reporting earned her great praise, especially from those who were unaware of what she had deliberately omitted from her reports. She was proposed for many journalistic awards, including a Pulitzer Prize. I felt an obligation to inform the Pulitzer Committee of her failings as an objective reporter. I wrote an open letter documenting the information I had provided Brown, and then wrote the following, quote, "So how did Pulitzer candidate Brown deal with all the evidence discrediting her primary source? She simply omitted any mention of it and presented Gouffre as an entirely credible witness with no doubts about her truthfulness. Brown deliberately and mendaciously misled her readers and the Pulitzer Committee by choosing to omit from her narrative every single document, sworn testimony, and other proof that would raise questions about the credibility of her primary source. She admitted to me in a consensually reported conversation that there is absolutely no evidence corroborating or supporting Gouffre's accusation against me. But she did not publish that important fact, nor did she publish the fact that Gouffre refused to accuse me on the record. This is not journalism. It is advocacy. And it is advocacy that would get a lawyer disciplined for willfully withholding exculpatory evidence. It is also advocacy that hurts the Me Too movement by encouraging false reports that damage the credibility of an important movement. Brown did not win the 2019 Pulitzer Prize. Before she's considered for any future prizes, her unprofessional tactics should be thoroughly and fairly investigated, which is more than she has done with regard to Gouffre. Brown is all too typical of reporting about Me Too accusations. For her, everything is black and white. Women, accusers, never lie about anything. Men who deny accusations do lie. There's no nuance or attempt to balance in her reporting. If there is evidence that a victim is lying, she will simply not report that evidence, regardless of how strong, because it will undercut her simple-minded and one-sided narrative. Other journalists as well don't dare to report facts that undercut the narrative that women tell the truth and men lie. If they do, or if they decline to publish false accusations by alleged victims, they are criticized by other media. National Public Radio, for example, recently did a segment on ABC TV's decision several years earlier not to run an interview they had conducted with Gouffre. The reporter, David Boies, wrote to me the following email, quote, I cover media for NPR, and I wanted to ask, I'd been told that you felt you were successful in persuading ABC News' legal team in not running an interview with Virginia Roberts Gouffre in 2015 because you convinced them she was untruthful, end quote. I assume, therefore, that he was interested in evidence that I provided to ABC that convinced them that she was untruthful. But as we shall see, that was the last thing he was interested in reporting. This is what I told Boies about my interactions with ABC. In mid-2015, I was sent an email that one of Gouffre's lawyers had circulated, announcing that an interview with Gouffre would be run on Good Morning America, the ABC Evening News, and Nightline. I immediately called ABC to inquire whether my name was being mentioned. They said it was not. To this day, she has not publicly or directly accused me out of court in order to avoid being held accountable for her defamation. I asked about Leslie Wexner, was told that his name also was not mentioned, perhaps because her silence about him was being negotiated. I told the producer that Gouffre has a long history of lying about prominent individuals, including the Gores and Clinton, as well as about other matters. I also told them about my conversation with Gouffre's friend Rebecca Boylan, in which she told me about the plan to obtain $1 billion from Wexner. I told him that these interviews with Gouffre were part of a shakedown plan, that Boylan had told me that Gouffre went on TV in order to send Wexner the following message. See, I have access to the media. This time I didn't mention you, but next time. The people at ABC said they would look into the matter, and I sent them the evidence. I made it clear that I was calling only on my own behalf and not on behalf of Epstein. I told the same thing to Boies when he interviewed me about this episode, but Boies had an agenda and a storyline, and reporting accurately what I told him would undercut his predetermined narrative. So this is what he falsely reported in the piece entitled, quote, How Media Fell Short on Epstein, end quote. Boies described me as Epstein's lawyer without disclosing that I explicitly told him that I had called ABC only on my own behalf as someone who had been falsely accused by Gouffre. Notwithstanding his expressed interest in how I convinced ABC not to run the interview, he never mentioned the evidence I provided to ABC and to him, proving that Gouffre had a long record of lying. Instead, he quoted Julie Brown, recently telling him, I found her to be very truthful and credible. But Brown had never told that to ABC back when they were making their decision. She only told it to Boies when he was doing his reports years later. So her biased and self-serving after-the-fact assessment of Gouffre's alleged credibility was completely irrelevant to ABC's decision, while my evidence, which I sent to ABC at the time, was highly relevant. Yet Boies deliberately omitted my evidence from his reporting. Accordingly, he made it sound as if ABC had succumbed to pressure from Epstein and his powerful friends rather than making a decision based on hard evidence that they received from me that Gouffre's lack of credibility did not satisfy ABC's journalistic standards. This is yet another example of biased and unprofessional journalism, this time by NPR, promoting the credibility of false accusers, even in the face of overwhelming evidence that they are lying, and attacking a responsible network for making the right decision based on the evidence they had at the time. This story, too, was fed to NPR by Gouffre's lawyers, an important fact they failed to disclose. The fear of being criticized for not believing an alleged victim, even one who was a proven liar, resulted in an article being spiked by the Daily Beast. I received a call from Lachlan Cartwright of the Beast. He had just read the unsealed emails between Gouffre and the journalist Sharon Churcher, in which Gouffre essentially admitted that she did not have sex with me. He expressed outrage at the obvious fact that I was being framed by Gouffre, who had been encouraged by Churcher to include me in her manuscript, even though she had never met me. Here is what he messaged me. Quote, Churcher crossed a massive line. Sharon Churcher inserts your name into Virginia's story, and people wonder why journalism gets a bad rap. End quote. Churcher stitched you up, he said. I want to blow this up, he continued. I suggest we set the record straight. No one has picked up on the Churcher emails. Have you been contacted by my competitors? Churcher basically over-egged what Virginia Roberts told them, and she was being paid for her story. End of quote. I told Cartwright that I blamed Gouffre rather than Churcher and that I had drafted an op-ed making this point. He pleaded with me to let him have the scoop. No, I want to write it, he insisted. This isn't a column op-ed, it's a news story. It's very shoddy journalism, so egregious, he told me. It will be much more powerful coming from me and the beast than coming from you. I agreed to withhold my op-ed pending the article. He asked me to send him the relevant materials, including the draft of my article and the documentary and recorded evidence, which I did. He told me he would get on it immediately and blow the lid off this frame-up as soon as he received approval from his editor. Well, that was the last I heard from him. Obviously, the editor of the Daily Beast, a website that made its reputation by uncritically supporting narratives of the Me Too victims, did not want to publish a truthful article that undercut the Me Too narrative by exposing an instance of lying by an alleged victim. To report honestly on Gouffre's false accusation of me was to risk being deemed by some to be disloyal to the movement and to the mantra that women must be believed even in the face of documented evidence that a particular woman made up a false accusation for money. Cartwright has refused to respond to numerous emails and messages. He's obviously ashamed of not publishing an important story he knows is true. The Beast should also be ashamed for refusing to report the truth about what they know is a false accusation. To quote Cartwright, quote, "It's very shoddy journalism, and people wonder why journalism gets a bad rap," end quote. Another story fed to the media by Gouffre's lawyers was a, quote, profile of me in the New Yorker that was anything but a profile of my 55-year career and 81-year life. It was a hatchet job calculated to destroy my reputation and silence me. In March of 2019, my publisher received an email from Connie Bruck, a journalist who writes for the New Yorker. She told my publisher that she was trying to contact me about a profile, much of it drawn from my books. My publisher gave me her number to call if I wanted to respond. The nature of her email made it clear to me that this was a cover-your-ass communication. She said she was trying to reach me. She could easily have emailed me directly, since my email is on my website, as is my office phone number. Nearly every criminal in the world has managed to reach me, but Connie Bruck had to go through my publisher. When I called, it became obvious she had no interest in speaking to me. She said she had completed the profile, and would I mind speaking to her fact checkers? I had never heard of a profile being completed without face-to-face interviews with the subject. She told me she had done several profiles without interviewing the subject. I challenged her. Isn't it true that in all of those profiles, the subject refused to speak with you? Sheepishly, she acknowledged that this was the case. Well, I wanted to be interviewed in person. I offered to fly to California to meet with her or have her come east. She refused, but agreed to ask me some questions over the phone. Her questions were all accusatory. It was more like an adversarial deposition than a journalistic interview. It was certainly not a search for truth or balance. She was not interested in my life, my aspirations, my family, and my values. She was only interested in confirming her pre-existing negative attitude toward me by asking gotcha questions. I later learned and wrote that the negative profile was proposed by Virginia Roberts Gouffre's lawyers in order to promote their case, and that it was approved by the New Yorker editor David Remnick as a way to silence me. Both Remnick and Bruck had relationships with Boies, and both despised President Trump, Prime Minister Netanyahu, and Israel. Destroying me suited all their agendas, so the project was launched. Bruck was so determined to dig up dirt on me that one of the first sources she Googled was rents.com, a neo-Nazi Holocaust denial website, which both the Anti-Defamation League and Southern Poverty Law Center have declared to be anti-Semitic. Several years earlier, this site had accused me of beating and murdering my first wife. She had died 10 years after we separated and divorced. It showed pictures of her and my children, which were not of them, but of stereotyped Jews with long noses. No one would believe anything on this hate site, no one, that is, except a journalist prepared to use any dirt, regardless of its source and absurdity, against her target. Bruck has admitted using this discredited site as the original source for claiming in her article draft that I abused my first wife and stripped her of custody of my two sons. She even used the same word she found on the Holocaust denial site. The truth is, my first wife and I, who were married when I was 20 and she was 19, grew apart. There was no abuse, and the court granted me custody based on a report of the social worker and on her explicit finding that I committed no misconduct. But that boring story would not achieve the New Yorker's goal of destroying me. So they went into the gutter and followed the lead of an anti-Semitic website. When Brooks' article was published, it contained telltale evidence of her reliance on this disreputable source. It reported that my first wife walked to the middle of the Brooklyn Bridge and leapt to her death. Police and medical reports prove that this is entirely untrue. It was an invention of Rents.com. After the article appeared online, Brooke was confronted with the evidence, and the New Yorker agreed to remove her false claim from the online version, though not from the hard copy. She now has to explain why she relied on Rents without any other evidence or source to include this false statement in her reporting. The fact checkers never asked me about it, even though they asked me about many other aspects of my first marriage. This reportorial bias alone is enough to discredit the article, but there were many more egregious errors in her article as well. I wrote a letter to the New Yorker correcting the errors, but they refused to publish it. They denied that they relied on Rents.com, but there was no other source for the fictional Brooklyn Bridge account, which had appeared subsequent to its original article claiming that I had murdered my first wife. Finally, the editor agreed to publish the following general letter, quote, "If anyone doubts the political bias of the New Yorker, I urge them to compare Jane Meyer's defense of Al Franken with Connie Brooks' screed against me, devil's advocate. Meyer resolves doubts in favor of Franken and against his accusers, whose motives she challenges. Brooke resolves doubts in favor of my false accusers, whose motives she does not doubt, and against me. The difference is that there is evidence that Franken did the things he was accused of, though there are doubts about whether what he did was sufficiently serious to warrant his resignation from the Senate. In my case, there is not a scintilla of evidence to support the false allegations against me by two women who Brooke concedes are, quote, imperfect witnesses, one of whom admits that she invented false accusations against other prominent people. Let me be categorical. I never met my two accusers. I have never had sex with an underage person. The accusations against me are totally false," end quote. In the end, the New Yorker's screed was largely a dud. Its bias, political, ideological, and personal, was so evident to most readers that it lacked credibility. It did not silence me, nor did Meghan McCain, though she tried to keep me off TV because, quote, "I'm being accused of Epstein-related improprieties." I had earlier been on The View, which features McCain, and had described the evidence of my total innocence. But for McCain, evidence of innocence is apparently not enough to overcome accusations of guilt. I wrote an op-ed in response to McCain's McCarthyite guilt by association, in which I warned, quote, "Imagine what America would be like if McCain's rule became the norm. Every accused person would be presumed guilty and shut down. Our traditional presumption of innocence would be reversed and a presumption of guilt would be substituted. That is the norm in today's China, Iran, Venezuela, and other totalitarian nations that do not operate under the rule of law." I am sure Meghan McCain would respond by saying that her rule should not apply to all cases, but only to allegations of sexual abuse made by women. There is no such limiting principle. Once an accusation, even a demonstrably false one, becomes the basis for punitive actions, including censorship, there will be no stopping the march toward abolishing the presumption of innocence. Accepting Meghan McCain's rule would encourage false accusations against political enemies in an effort to censor them. One virulently anti-Israel website acknowledged this weaponization of accusations when it wrote the following, quote, "We have picked up news about the sexual allegations against Alan Dershowitz because Dershowitz is such an outspoken supporter of Israel, and the matter has inevitably affected his influence in the foreign policy arena," end quote. Others have told me that they are happy that I'm being accused because it will silence my voice when it comes to defending the legal rights of President Trump. If an accusation becomes enough to silence a controversial speaker, the inevitable result will be the increased weaponization of false accusations. As a young man, I lived through an age in which accusations were deemed sufficient to keep someone off television and other media. That age was called McCarthyism. Meghan McCain's rule would return us to a terrible time in our history. So let us maintain the presumption of innocence for all. Let's not let accusations be equated with convictions. Let's assure every person accused is accorded the due process right to disprove the accusation. I hope Meghan McCain, who I admire, will reconsider her thoughtless demand that I be banned from television on the basis of an accusation that has been thoroughly disproved and discredited. End of quote. McCain apparently refused to reconsider, and a tentative invitation for me to appear on The View to discuss my book Defending Israel was withdrawn. Even the Columbia Journalism Review, the self-proclaimed voice of journalism, was willing to violate core journalistic ethics in the service of the Me Too movement. A reporter named Liz Lenz called to interview me. She agreed our conversation was off the record. When I described myself as a victim of false accusations by Giuffre and her lawyers, she replied, quote, "You're a rich white man. You can't be a victim," end quote. I responded that she wasn't being an objective reporter. She then screamed at me and said she was going to put that on the record, despite our prior agreement that it was off the record. Quote, "You don't get to insult me off the record," end quote. She then published my off-the-record criticism of her, a clear violation of the ethical rules of journalism. She went further and published the false claim that this book, which she had not yet read, will blame, quote, "the Me Too movement for my trials," end quote. Of course, this is not the case. I am blaming those who abuse the Me Too movement for the false accusations against me being credited by biased journalists like Lentz. Lentz then defamed me by falsely accusing me of rhetorically advocating sex with minors, despite my unambiguous statement that I was making a constitutional, not moral argument that the age of consent should be the same for sex as it is for abortion, an argument several prominent feminists have made. Some in the media have played a commendable role in starting the Me Too movement by exposing predatory practices by many men. But the media in general has refused to engage in nuanced reporting about those few women and their lawyers who have tried to take advantage of a positive movement to turn it into a self-serving racket of leveling false accusations for profit and revenge. The time has come for responsible media to investigate plausible claims by victims of false accusations. It will take courage to do so. The Wall Street Journal showed the way years ago when it exposed fraudulent accusations of child abuse that had resulted in imprisonment of innocent owners of daycare centers in Massachusetts, California, Washington, and other states. This expose did not hinder the prosecution of real abusers, but it forced prosecutors, parents, and journalists to distinguish genuine cases of abuse from fraudulent accusations. It was a win-win. It will also be a win-win if the current media were to substitute investigation of actual innocence for presumption of guilt based on accusations alone. Thus far, the media in general has refused to play this important investigative and reportorial role. Chapter 11, I demand to be investigated. When it became clear that I would never be vindicated by the current media because of its insistence on uncritically presenting only the narrative of the alleged victims of sexual abuse, I decided to make a bold move, a move that only a completely innocent person with nothing to hide would ever consider making. I demanded an investigation of me by law enforcement. This move came about in several steps. First, I arranged to meet with prosecutors and investigators in the offices of the United States Attorney for the Southern District of New York and the District Attorney of Manhattan. I began my meetings with federal prosecutors and the FBI by stating I am aware that lying, even not under oath, to law enforcement officials is a serious felony punishable by imprisonment. I then said, although I'm not required to deny my guilt, I want to state unequivocally that I never met my accusers and never had any sexual or other contact with them. I could see the FBI agents writing down every word I said. If it were to turn out, as I knew it wouldn't, that I was lying, they would have all the evidence they ever needed to send me to prison. I then proceeded to lay out the case that Giuffre and her lawyers had tried to frame me as part of an extortion plot against Leslie Wexner. I presented the evidence, including recordings, calendars, testimony, and chronology, that demonstrated how Giuffre and her lawyers had falsely accused me publicly, while at the same time accusing Wexner secretly of nearly identical conduct. I told them that both Wexner's wife and lawyers had used the word shakedown in describing the efforts by Boies to, quote, resolve the matter. The agents took extensive notes of everything I said. The prosecutors came into the room with several volumes of what appeared to be testimony or evidence. Both my lawyer and I surmise that these volumes related to other investigations of Boies the feds may have been conducting. The media had pointed accusatory fingers at Boies for his role in the Theranos case, involving a fraudulent blood testing startup on whose board Boies served while simultaneously acting as the lawyer for the company, a clear conflict of interest. The founder and CEO of the sham company was indicted, and there was speculation she might be flipping on Boies and providing evidence against him. There was also speculation that Boies might be the subject of an investigation growing out of the misuse of private investigators hired by Boies in the Harvey Weinstein case. The media was also raising ethical and legal questions about Boies' involvement with a corrupt Venezuelan politician and entrepreneur. No one was doubting Boies' right to represent these people. It was the manner by which he was acting for them that apparently interested investigators. As usual, the federal prosecutors and agents did not tip their hand. They made it clear they were there to listen, not to talk. They were cordial, but we left the meeting convinced they believed me, but uncertain about whether they would move forward against Gouffre and her lawyers. My meeting with prosecutors and agents from the Manhattan District Attorney's Office was very different. I presented essentially the same evidence to them I had to the feds. The chief prosecutor, just below the district attorney himself, Cyrus Vance, questioned me and extensively asked for more details, which I provided. I played the recordings for them, and they agreed that our transcripts of the recorded conversations with Boies and Boylan were accurate. Then I received a shocking phone call from the chief prosecutor. He told me that Cyrus Vance had decided to recuse himself and his entire office from the matter because he was too close a friend of David Boies, who had also made significant contributions to his election campaign. They would send the case to a different district attorney's office, perhaps in Queens or Staten Island, who would then take over the investigation and be in touch with me. I began to prepare a packet of evidence to bring to whichever district attorney's office took over the case when I received another, even more shocking call from the Manhattan prosecutor. Cyrus Vance has changed his mind. He was unrecusing himself, and his office would decide whether to prosecute Boies and Gouffre for extortion and related crimes. Not surprisingly, Boies decided not to further investigate or prosecute Boies. The reason they gave was that Wexner refused to cooperate. I responded that victims of extortion rarely, if ever, want to cooperate, especially if the sins or crimes they paid hush money to hush up had not been exposed. That was the situation with Wexner. Following his meeting with Boies, Wexner's name disappeared from the case. Why would he want the accusations against him to be made public, as they would inevitably be if Boies and Gouffre were to be put on trial for extortion, attempted extortion, or conspiracy to extort? Finally, after not hearing anything from the feds and being told there'd be no action by the district attorney from Manhattan, I decided to go public. I published a provocative op-ed in the Wall Street Journal entitled, "I Want to be investigated by the FBI." My op-ed began as follows, quote, "If you are accused of a crime, you are entitled to a presumption of innocence. But in the age of Me Too, people accused of sexual misconduct are subjected, at least in the court of public opinion, to a presumption of guilt. Worse, a claim of innocence, even a provable one, is itself treated as an offense, an assault on the accuser and on survivors in general." I then observed, "Yet there are some in the Me Too movement for whom there is no such thing as innocence. Despite having proved I never even met my accuser, my appearances on college campuses have been greeted with protests accusing me of being part of the rape culture. People on Twitter have called me a child rapist, and worse, there were calls on social media for Harvard to strip me of the emeritus status I earned after 50 years of teaching without a single complaint." I concluded the op-ed with my challenge, quote, "I've decided, therefore, to do something unusual. I'm asking the federal prosecutors and the Federal Bureau of Investigation to open a criminal investigation of me, but not of me alone, of my accusers as well. They have filed sworn affidavits in federal court. These affidavits are in irreconcilable conflict. I have sworn that I never met either of them. They have sworn that I engaged in sexual acts with them. Either I committed perjury or they have. Someone has committed a serious felony, a crime against American justice system. I'm asking law enforcement to figure out who it is. I will cooperate, showing them my evidence, testifying before the grand jury, invoking no privilege. I will challenge my accusers to do the same. It's no fun to be investigated for a felony by the FBI, but the current state of law and public opinion gives me no alternative if I want to be vindicated. In more than half a century of litigating criminal cases, I have never seen one in which the evidence of innocence is so incontrovertible and the evidence of guilt so non-existent. If my evidence is inconclusive, then no falsely accused person can ever clear his name, end quote. The sad reality is some of my critics believe I'm guilty despite the evidence. They conflate my representation of Epstein and helping him get what some regard as a sweetheart plea bargain with the false accusation that I had sex with Epstein's victims. But the two are completely different. I did what the law and legal ethics obliged me to do in my role as Epstein's lawyer. I did what I'm accused of, namely helping to get the best possible deal for him. All lawyers should seek that once they decide to represent a client. In my opinion, no good lawyer should refuse to represent a client because he is despised and accused of heinous crimes. In representing a client, the lawyer must, of course, play by the rules, both ethical and legal, which I have done. In contrast, I have never engaged in illegal sexual behavior or improperly touched any female associated with Epstein or anyone else. Of those false charges, I am totally innocent and a victim of perjuriously false accusations. So the two accusations, that I represented Epstein and that I had sex with anyone associated with him, should never be conflated or confused. The first was the right thing to do and I did it. The second would have been wrong if I had done it, but I didn't do it. For some thoughtless critics, the fact that I represented Epstein makes it more likely that I had sex with his victims. To the contrary, if I had engaged in improper sex with anyone associated with Epstein back in 2001 or 2002, which I did not, I never would have agreed to represent him in 2005 and 2006 and be in the limelight as his lawyer. The fact that I successfully represented him does, however, make it far more likely that I would be subject to a false accusation by one of his victims, angry at me for helping Epstein get a, quote, sweetheart deal, which denied her justice. Both of my false accusers have acknowledged that they despise me and wish me ill for having represented Epstein, thus providing a motive, in addition to the financial motive, for falsely accusing me. I, on the other hand, have no motive to attack them other than to clear my name of false accusations. I do not know them, have never met them, and have nothing against them other than they have falsely accused me, which is quite a lot. We live in such a polarized world today that there are even some who conflate my controversial support for President Trump's constitutional rights with the accusation against me of sexual misconduct. As one person put it to me, quote, anyone who does anything that helps Trump has no morals, so I can believe you do anything, end quote. Another said, quote, I was hoping you were guilty of the sex stuff because that would have shut you up about Trump. But damn it, the evidence proves you didn't do it. So I guess you'll keep blabbering about Trump, end quote. An anti-Israel website expressly associated accusations of sexual misconduct with my defense of Israel, colon, quote. We have picked up news about the sexual allegations about Dershowitz because Dershowitz is such an outspoken supporter of Israel, and the matter has inevitably affected his influence in the foreign policy area, end quote. I welcome a full and fair investigation. It may be the only way in this Me Too age of presumed guilt to finally and fully prove that I am totally an innocent victim of false and perjurious accusations. Chapter 12, being sued for telling the truth, a grave danger to the First Amendment. In March of 2019, Virginia Roberts Giuffre sued me for defaming her by denying her false accusations and calling her a liar and perjurer. Julie Brown, the so-called journalist who was working hand in hand with David Boies and Giuffre's other lawyers, knew about the lawsuit before I did. She was shown the complaint before it was filed and had a lengthy story ready to go. She also helped Giuffre's lawyers gather information from me on the pretext that she was acting as a journalist, anxious to see my evidence, rather than as an investigator helping Giuffre's lawyers in suing me. The lawsuit itself violated the spirit, if not the letter, of the First Amendment by asking the court to punish me for denying a false accusation. If every public figure was sued for denying accusations, true or false, and calling his accuser a liar, the courts would be so filled with defamation suits that there would be little time for anything else. Think about all the times current politicians, from the president on down, have called their political opponents liars or have accused them of making up stories about them. I remember when Adlai Stevenson promised that if his opponent stopped lying about him, he would stop telling the truth about his opponent. From the beginning of our history as a nation, the word liar has been bandied about by politicians, journalists, academics, and ordinary folks. Jefferson, Hamilton, Burr, Jackson, Lincoln, Roosevelt, Kennedy, Johnson, Carter, Reagan, Clinton, Obama, and Trump have all been called liars, and some have responded in kind. J. Edgar Hoover called Martin Luther King the most notorious liar in the country. A simple check of Google will show others who have been called liars include the following: Ralph Nader, Nancy Pelosi, Al Sharpton, George Bush, Jesse Jackson, Eric Holder, Adam Schiff, John Kerry, Ted Cruz, Al Gore, Elizabeth Warren, Loretta Lynch, Henry Kissinger, Barney Frank, Michelle Obama, Condoleezza Rice, Antonin Scalia, Brett Kavanaugh, Clarence Thomas, Phil Murray, John Lewis, and Michael Bloomberg. There are even websites that catalog those who have been called liars. Rarely has the person called a liar responded by suing. The expected response is in the marketplace of ideas, or in the development of a thicker skin, especially by those who initiated the exchange of verbal epithets by hurling the accusation in the first place. It was Sigmund Freud who declared that the beginning of civilization can be marked by the first person who hurled an insult instead of a spear. In the old days, a person falsely accused of a sex crime might challenge his accuser to a duel. Today, they should be free to call the accuser a liar, as I did. That's how the marketplace of ideas and epithets works. The word liar has become so overused that it has lost its sting and its power to inflict damage on the person accused of lying. Gouffre's lawyers know this. And so it's unlikely that the real purpose of their defamation suit was actually to prevail in court or to obtain damages. There couldn't possibly be any damages, since I have been calling Virginia Roberts Gouffre a liar and perjurer since the beginning of 2015, when she first falsely accused me. The statute of limitations is 1 year, and so the damages would be for what I have said during the past year, not before that. But I said nothing different during the past year than I said for the previous 4 years. Moreover, it is clear from Gouffre's own words that I told the truth when I called her a liar, and the truth is an absolute defense to defamation. Gouffre will have to admit that she lied when she made up stories about Tipper Gore, Al Gore, and Bill Clinton, when she claimed that she was below the age of consent at the time she was allegedly trafficked by Epstein, when she said her manuscript, in which she names the real names of those with whom she claimed to have had sex, was intended to be, quote, fictional. She has told many other lies as well, so truthfully calling her a liar and a perjurer is not defamatory and could not have caused her any material damages. I will argue that Gouffre became a public figure when she sold her story for $160,000 and peddled her manuscript seeking a big advance. She also deliberately thrust herself into the limelight by accusing me and others of sexual misconduct and having these accusations leaked to the press. Her recent appearances in front of TV cameras, on the courthouse steps, and her network and newspaper interviews confirm her status as a public figure, subject to the more daunting legal criteria for prevailing in a defamation suit. She didn't become a public figure by being a victim. She became a public figure by exploiting her alleged victimization for profit, publicity, and revenge. Public figures don't win defamation suits based on being called a liar. When they initiated the verbal exchange by falsely calling their accuser a pedophile. Gouffre's lawyers have argued that I did not have the constitutional right to defend myself against an accusation that I was a, quote, pedophile by calling my false accuser a, quote, liar. Here are their exact words, quote, Dershowitz's statements fall outside of any privilege because they are disproportionate to any statement he was responding to. Disproportionate. I quote their exact words because no reasonable reader would actually believe that any rational lawyer would argue that calling a person a liar who accuses you of being a pedophile is a disproportionate response. In any event, Gouffre also called me a liar, and so me calling her a liar cannot be deemed a disproportionate response. The courts are not the appropriate institutions to rule on liar, liar, pants on fire exchanges. Gouffre's lawyers have also argued that the mere denial of a sexual assault constitutes defamation. Here is what they said, quoting a prior opinion by a district court judge. Quote, to suggest an individual is not telling the truth about her history of being sexually assaulted as a minor constitutes more than a general denial. It alleges something deeply disturbing about the character of an individual willing to be publicly dishonest about such a reprehensible crime. If the courts were to rule that I had no First Amendment right to suggest that Gouffre was not telling the truth about me, such a ruling would establish a dangerous constitutional precedent. It would chill the exercise of free speech and incentivize politicians and others to clog the courts with defamation suits rather than responding to accusations of lying in the marketplace of ideas. It would also encourage lawyers to engineer defamation suits by employing the sleazy tactic used against me, namely, defaming me from behind the litigation privilege and then suing me for truthfully denying the false accusation in public. In my opinion, the real purpose of the lawsuit was threefold. First, to defame me and lie about me in the pleadings on the assumption that these pleadings are protected from defamation lawsuits. Second, to punish me economically by requiring me to spend money on legal fees and heightened insurance premiums and to take time from my other work I am doing. Third, to try to get me to settle in the way that Epstein settled his cases, giving the plaintiffs and their lawyers a windfall. Before these suits were settled, I had volunteered to testify against Gouffre and Ransom and prove they had lied about me so their credibility was in question. But I had no control or influence over Epstein's decision, and the cases were settled, presumably not for financial reasons, but out of concern for what might come out at trial. I have no such concerns, because I have done nothing wrong and have nothing to hide. Notwithstanding the illegitimate purpose behind filing the defamation suit, if I were to go to trial, I would be able to subpoena material that is currently under seal or hidden, and my lawyers would be able to cross-examine Gouffre about her numerous lies and about her emails and manuscripts that prove that she never met me or had sex with me. I would also be able to introduce my detailed travel and other records, which prove that I could not have been in Epstein's island, ranch, or other places at which he falsely claims to have met me. Finally, if Gouffre claims under oath in front of a federal judge and jury in a federal courthouse that she ever had sex with me, she will be subjecting herself to criminal perjury charges. I will truthfully swear under oath that I never met her. One of us will be committing perjury in a federal courtroom, an intolerable situation if not investigated and prosecuted. Accordingly, I have asked the FBI to attend the trial and to investigate which one of us is the criminal. The evidence will show it was her. Some of my critics have alleged that I am being inconsistent by raising First Amendment objections to the defamation action, since I invited a lawsuit in order to prove my innocence. But there is nothing inconsistent about seeking both goals: the right to defend myself under the First Amendment in the court of public opinion against false accusations, and the right to prove my innocence in the court of law if my First Amendment rights and those of all Americans are compromised in the name of the Me Too movement. On October 16, 2019, Judge Loretta Preska ruled that it was for the jury to determine whether my statements regarding Gouffre's accusations and calling her a liar and perjurer come within the First Amendment self-defense privilege. I am confident that a jury hearing all the evidence will conclude that I am telling the truth when I say I never met her. We raised the First Amendment issue in a motion to dismiss in order to preserve it for trial and possible appeal. I look forward to a resolution that both protects my First Amendment rights to defend myself against false charges and that totally exculpates me from any suspicion that I ever met this false accuser. Conclusion: it could happen to you. What have I learned from being falsely accused of heinous crimes by women I never met? After more than half a century of representing hundreds of accused defendants, some of whom were guilty, others innocent, I finally learned what it actually feels like to be a totally innocent and falsely accused defendant. Although I haven't been accused of any crime by a prosecutor and don't face criminal prosecution, in some ways it's worse to be accused by an individual woman in the age of Me Too. A criminal defendant has the opportunity to prove that he's not guilty. A man falsely accused of sexual misconduct by a woman has far less opportunity. I know I did absolutely nothing criminal or even wrong. I'm proud of the way I've conducted my private and professional life, during my long career as a professor, lawyer, and public intellectual. But many people, mostly strangers, actually believe, despite overwhelming evidence to the contrary, that I had sex with Virginia Roberts Gouffre when she was underage and with Sarah Ransom when she was 22. The social media are replete with tweets and messages calling me a pedophile, a baby effer, and a pervert. It's a horrible feeling to know that people not only believe, but they know that I did something I myself would regard as reprehensible. In the introduction to this book, I asked the reader simply to imagine, before seeing the evidence, my innocence, in order to imagine how you would feel if you were falsely accused. Now that the reader has been presented with the indisputable evidence of my innocence and the total absence of any evidence of guilt, that assumption should become a certainty. Every reasonable reader should agree that I am the victim here, the victim of a perjurious frame-up by women with long and continuing histories of lying for money about prominent men. Readers should also agree that these women, Gouffre and Ransom, as well as their lawyers, should be investigated for the roles they played in these criminal activities. Yet there will be some who will be unwilling or unable to disbelieve a false accusation by a woman, regardless of the evidence and the lack thereof. There will be others, like the reporter from the Daily Beast, who know I have been falsely accused, but lack the courage to take on the Me Too movement, even in a case as clear as mine. If my evidence is not enough, then no evidence will ever be enough to prove innocence. If this state of evidence is allowed to become the new basis for determining guilt, then we will surely have moved to an age of guilt by accusation rather than by proof. The important lesson for all Americans is that if this can happen to me, if I can be falsely accused and have my reputation tarnished by a frame-up plot with no evidentiary support, it could happen to anyone, to you, to your son, to your father, even to your daughter. I have the resources and the determination to fight back and to clear my name, though it has cost me a small fortune. David Boies has told people that even if he can't defeat me in court, he can bankrupt me with legal fees. He and his giant law firm have the capacity to bankrupt individual opponents by filing frivolous and insubstantial lawsuits. They have a sordid history of bullying, of conflicts of interest, and other ethical violations. Boies will stop at nothing to even perceive scores, even if it hurts his law firm, as his vendetta against me has done, much to the chagrin of several of Boies' partners, who are furious at him for what one characterized as his, quote, Ahab-like obsession with killing the white whale, namely me. They know that I will do everything legal and ethical to clear my name and prove his complicity with evil. If he and his clients are allowed to get away with their plot to falsely accuse me, it would open the door to more false accusations against innocent people who do not have the resources to fight back. The federal court has now ruled that Boies and his law firm are disqualified from representing Gouffre against me. Boies will be a crucial witness in my trial. If he tells the truth, he will be a witness to my total innocence and the falsity of the accusations against me. This is everyone's battle, not just mine. It is a battle for justice for all. It is a struggle against those who bear false witness. The Bible commands justice, justice shall you pursue. The word justice is repeated because there must be justice both for the victim of false accusations and for those who falsely accuse. I will not rest until justice comes to me as well as to those who have borne false witness against me.
This concludes the reading of Guilt by Accusation, The Challenge of Proving Innocence in the Age of Me Too, by Alan Dershowitz. Copyright 2019 by Alan Dershowitz. This book was read by Alan Dershowitz. This unabridged recording was published by arrangement with Skyhorse Publishing and was produced in 2020 by Blackstone Publishing, which holds the copyright. Neither this recording nor any portion of it may be reproduced or used for any purpose without prior written authorization from Blackstone Publishing. If you would like to obtain a monthly update telling you about new releases, Call 1-800-SAY-BOOK. That's 1-800-729-2665. For a complete listing of our titles, visit our website at www.downpour.com. Thank you.
Audible hopes you have enjoyed this program.